afternoon. My name is Cindy Hepfer. My co-planner, Pamela Blue, and I welcome you to the fifth in a series of ALCTS webinars on institutional repositories. Today's presentation, which is sponsored by B Press, will address the critical topic of copyright and the ownership of intellectual property. We are honored to have as our presenter Professor Dwayne Buttler, who is the Evelyn J. Schneider Chair for Scholarly Communication at the University of Louisville. Professor Buttler holds a J.D. from the Indiana University School of Law, Indianapolis. He is also chair of the ACRL Copyright Committee. Dwayne will take questions during the webinar as well as at the end of his presentation. Audience members can submit questions using the text box on your screen. Although the webinar is slated for 1 hour, we can run a little longer if questions warrant additional time. Dwayne, over to you.
Hi, how are you all? Good afternoon. I'm just delighted to be here, and I'm interested in talking to you all about copyright. It's a little bit awkward because just shortly before the show started, I had some odd things going on outside my room, so I've run down the hallway and I'm now sort of reconditioning my thinking and see where we're going to go from here. I'm going to talk about copyright in lots of different ways, and one of the things that interests me is that I'm going to frame it in an institutional repository kind of context. And as we go along, I'm open to questions at any time. You can probably get a sense that not having opposable thumbs is going to be a little bit of an issue, but if you bear with me on the technology aspects of it, then I think we'll go fairly well. I do actually have a PowerPoint show which will look something like this. And it's cleverly entitled Copyright Ownership and IRs, and this is me. I'm actually not a dog. And in that context, I wanted to know also after we're done talking today that you can email me. I get tons of emails from throughout the United States on questions related to copyright. And also, I guess I should emphasize this is going to be about U.S. copyright law today, and probably not going to incorporate other kinds of questions. And I think fundamentally that the focus is going to be on institutional repositories writ large, I guess, in that cliched kind of way. And that conversation is going to be the notion of why we're interested in copyright. So I'm going to start framing it that way. As many of you know, and for those of you that don't, we can sort of think about it in the same way, is that copyright is a very broad federal law that protects all original works that are fixed in a tangible medium of expression. So if I think about an institutional repository, or if I think of the context or how I'm going to use copyrighted works, I'm pretty confident that there are going to be some issues related to the use of copyrighted works. So we're going to have some sense of whether we know something about ownership, whether we know something about issues related to how to make use of them in some kind of construct. And some of that conversation we're going to have today is really about licensing and the construct of licensing. And some of it's going to be about issues related to how other exceptions might occur, but most of it's going to be focused on ownership and licensing. Copyright is an exceedingly long duration entity, and the current framework for U.S. law now is life of the author plus 7 years, so it's a very long time that we have to think about the copyright issues, and that's grown through time. It's gone from approximately 28 years in 1790 to the life of the author plus 70 years, and because of various developments in the law, I can anticipate that that's going to enlarge or grow through time. And the other thing is that it's hard for me. I've been doing this for a number of years now, and it's hard for me to avoid copyright in most of my conversations, and it may be because I talk about copyright a lot, but also I think it's because it shows up in the Chronicle for Higher Education, it shows up in the New York Times, it shows up in relationship to technology, and it shows up in relationship to devices. So in that context, I view it as pervasive or ubiquitous even in some sense. One of the other things that I think we also need to think about is this basic framework. And I realized that the concept of basic questions is fundamentally basic, but I also have found in my teaching through the years that usually it's good to revisit the basic kinds of questions to structure a conversation. So what I'm thinking is that if I look at this, the basic framework I want to know is the work protected by copyright at all? And that's a fundamental question, and we can talk somewhat about possibilities, but as a general proposition, I'm going to err on the idea that most things are going to be protected by copyright because of that original work fixed requirement. And if it's so that it's protected by copyright, then the second question I'm going to think about is who owns that copyright. And that's going to be fundamental, I think, in understanding the institutional repository construct. The third aspect of copyright is that many of the things that are produced, or at least some of the things that are produced, also include other copyrighted works within them. So in the context of institutional repositories, in a very strict sense, as articles or those kinds of things, or even in a larger construct of the much other kinds of materials that folks are including in institutional repositories writ large, a lot of those are third-party works. So we also need some sense of that aspect of copyright. So that question, I think, is going to be part of a structural construct. So the fourth question, I guess, is how do you want to make use of the deposited work? And I'm going to use deposited in the construct that we're talking about as the institutional repository, so I tend to think that we're going to mostly think of them as deposits. And I'm not sure I'm actually getting questions about the slides, but I'm not confident that I know why that they're not showing on the screen. I see them full screen on my machine, so it's a puzzle to me as to why they're not showing. Okay, so the question is, how do I want to make use of the deposited work? And that fundamentally is the nuts and bolts, I guess, of this conversation. So we'll move forward from there and see what happens. Okay. How do we get copyright? And I touched on that already. The notion in the United States is that it's original work of authorship, and that originality is a very low threshold. It's something beyond a basic list of alphabetized facts, which is pretty simple threshold. So it does have to have some modicum of creativity, in the words of the courts, but that's not much of a threshold. So there again, I'm going back to my presumption that there is some originality, that it is original work of authorship. And then the next question is it fixed in some tangible medium? So if you're looking at it, if you can read it, if you can hear it, the odds are that it's protected by copyright because it's met that originality requirement. It's fixed in that tangible medium. And the next aspect of that is that there are actually, it's automatic protection. It's automatic protection. So in that sense, we have really that presumption, again, that they're protected by copyright. And these are the sets of rights that we're talking about in the copyright context. If we go to this construct of what are the rights that we're talking about, rights in the United States are reproduction. So in other words, if you're the owner of the copyrighted work, you can prevent anyone else in the world from reproducing that copyrighted work. You can prevent anyone else from distributing that copyrighted work. You can prevent anyone else from preparing derivatives based on that construct. That's a pretty straightforward concept of if the second work's based on the first work. The classic example that I tout occasionally is the idea that Stephen King writes a book today and tomorrow they make a motion picture of it. That motion picture is derived from the original, and there are performance and display issues and protections under copyright law, they have to be public, which is going to be a consideration. And it's hard for me to envision in most situations involving an institutional repository where we're clearly going to implicate the first right of reproduction, because typically if we want something digital, then there's going to be a copy of it. We're looking at a good prospect that it's at some point going to be distributed or downloaded or whatever terminology we want to have. One of our concerns might be, not uniformly, but certainly in the view of some folks in the world that also understand copyright and address copyright on a regular basis, that some issues related to how do we move forward with respect to formats and things like that are also going to be questions of how and to what extent that may be a derivative work. I'm not necessarily in that camp, but I think it would behoove me to talk about that in some context. And then the public performance and display issues are probably going to require some media kind of thing. So if the institutional repository, and I wasn't going to spend a lot of time on this, but if the institutional repository is something that involves audio, video, sound recordings, or those kinds of things, then there could be potential questions related to performance and display. And as a practical matter, each one of these if you want to put it in the liability construct, or if you want to put it in the framework of what's going to happen to me or something like that, then usually there's a different counts of infringement in the sense of copyright law. So what you'll find is that the plaintiff will say that you've reproduced it, you've distributed it, you possibly have prepared derivative works, performed a display. And each one of those has some accounting with damages as we go along. Okay, and just to not belabor the point, but going back to that duration, because I think that people are occasionally forget this duration question of life of the author plus 7 years. And then on the other aspect of copyright law is the notion that the United States fundamentally reconstructed its copyright law in 1976. So the framework is that I have to look at works created after 1978 and works created before 1978 as different animals with respect to duration. And as a general principle, the lower formula of 28 plus 47 plus 20 years is something like things in the United States produced in the United States prior to 1923 are in the public domain. Well, those may or may not be institutional repository deposits in some institutional repositories, but other institutional repositories that are more of the preservation ilk, I guess, are moving quickly into that conceptually. So if we move on to ownership, this is my real photograph, unlike the facsimile you saw earlier. But you can see a remarkable. I'm actually the guy in the middle, so I'm not Richard Nixon. I'm not Elvis Presley. And in that context, the ownership question is something I want to talk about most of the time. And then I'm going to run through some possibilities of a series of questions that you might think about in an institutional repository context. Okay, one possibility with respect to the copyrighted work is the creator of the copyrighted work. And I think that's pretty intuitive in some sense, and I don't think there are any great surprises there. If you are the person creating the originality, so to speak, and then fixing it on some tangible medium of expression, I think it's intuitive that that's possibility would be that you'd be the copyright owner. So I'm thinking of the easiest example of I take a photograph on vacation. You know, I'm not handing the camera to someone else, but I'm actually taking the photograph. I'm pushing the button, and I'm using a camera, whether it's a traditional camera or a cell phone camera or whatever devices collect images now. And there are no other relationships or conditions that I'm going to be the owner of that copyrighted work. And that's functionally, in a legal sense, an operational law. The federal copyright law steps into your life and says that I know that you want copyright protection for this, and I'm going to give it to you. I'm going to give you the sets of rights, reproduction, distribution, public performance, public display, and preparing derivative works, and I'm going to give those to you for life of the author plus 7 years. And so in my conversation as I move forward, I'll talk about author, but I also want you all to be comfortable and understand that author is the term from copyright law, and copyright clearly can apply to photography and computer software and sculptures and paintings and all those kinds of creative endeavors that might have original expression. So if I use the author construct, in most situations I'm really using it in a copyright sense. And then we have this interesting quandary with respect to the academic world and the whole obsession with intellectual property and how we deal with intellectual property. And I have to sort of, I think, go forward and then back up if that helps. Another possibility in copyright law is something called the work made for hire doctrine. Work made for hire doctrine says that the employer of an employee owns the copyright in the works produced by the employee who is acting within the scope of their employment. You just can't have more fun than talk about copyright law. The scope of employment typically would be thought of as something that you're hired to do, and if you create copyrighted works in that framework, then your employer owns it and not you. And lots of classic examples of that might be software engineers, folks who make motion pictures, and all those good things. And typically in most university settings, in most situations, we think of staff as having that notion of work made for hire. So in that context, it's really your employer and not you individually that controls those exclusive rights of copyright. And in that context, we also have this question that's been going on for quite some time about is a faculty member an employee of an institution in a work made for hire sense? And it's not clear under case law, because as you know, lawyers are very interested in lawsuits, and we have the federal statute, and we have courts interpret it, and I'm very interested in what courts have to say about the statute. And in that framework, we tend to find that it's not clear the status of faculty members with respect to work made for hire. To put it another way, I think there's an even chance that the faculty member could be considered an employee, and therefore the employer, the university, would own their copyright, or the faculty member could be considered not an employee, and therefore the faculty member owns that copyright. And that's going to become important for you all to determine how and if and to what extent that you want to deal with understanding, and I think you should address who owns copyrighted work. So if I can go backwards, I come up with this question of the academic world and intellectual property policies. And one of the other conversations, or one of the other things I'm going to urge you to do today is to understand the intellectual property policy at your institution. And in that context, the intellectual property policy is really going to define the kinds of rights that you might have with respect to the ownership of your intellectual property and who owns it. So in that framework, you need to know the intellectual property policy. And I can say as a general proposition that across universities it's approached in different ways. And part of the goal is to resolve that seeming ambiguity in work made for hire. So we don't need to determine whether a faculty member is a work made for hire or not. We say as a policy initiative that certain kinds of works are going to be owned by the university and other kinds of works are going to be owned by the individual faculty member. And in that carve out, what we usually find at most institutions is that the traditional work of scholarship, and sometimes we need to talk about what that is, and sometimes in a policy framework we have lots of questions about definitional. So if you've ever seen an intellectual property policy, you can imagine that they're drafted in ways where we struggle with identifying traditional works of scholarship and what those are. But as a general rule, those kinds of things will at least extend to articles and those sorts of works that, not surprisingly, scholars have traditionally done. So the titling, I guess, is not a strange aspect to it. And if that's true, then one of the places we look for understanding ownership is does the university own it or does the faculty own it? And for some institutional repositories, particularly those that are interested in deposits of writings, traditional scholarship, articles, whatever nomenclature you want to use, most likely the faculty member is going to own that work. And layered on top of that is a growing question that relates to, are there any conditions of the underlying funding or the grants that related to that conceptually, and we may at some point need to address that question. The National Institutes of Health has some requirements with respect to certain kinds of publications that result from NIH funding, and I think that there's a bill in Congress right now that may expand that to other settings. It doesn't necessarily change the ownership per se, but it becomes a factor in assessing, with respect to the deposit, who has the rights and what can the repository do in that context, and who do they need to talk to and who do they need to ask. So let me move back to work made for hire and move beyond work made for hire and move into the section where we have the question of, if it's not work made for hire, what is it, and how do we know if it's work made for hire? And this goes back to my conversation about, determining who's a work made for hire. This may occasionally come up. There may be kinds of materials that you want in a repository that have been produced seemingly for the university, but they're not produced by employees of the university. So in that context, one of the questions I would want to know is that, is it actually a work made for hire, which means the university owns it, or under the policy the faculty member could own it, or was it an independent contractor? So you have visiting faculty, you have those kinds of things. And in that construct, really we want to know is who controls the product, who designed the project, who provides the tools, those kinds of factual informations. And we don't know that. Sometimes we need to find that out, because if it's not a work made for hire, it could be owned by that individual, and that individual actually could be controlled by another institution's policy. So it gets a little bit sticky at times with respect to how we determine that. And then the other fundamental question I think that we really start to need to think about, so if we know it's an original work and it's fixed, we know something about the ownership for many kinds of materials resting with the faculty member if those materials are traditional works of scholarship. For other things you might put in a repository, you all may ask me questions about that and who might own those. But as a general proposition, we need to know something about ownership to start understanding how we populate institutional repositories. And that question is really going to become more prevalent if we look at how and to what extent there have been assignments of that material prior to it moving into the repository. So in other words, it's possible that, and been fairly typical and not at all unusual for publications of faculty in the academic world to include a publication agreement. And that publication agreement, at least more often than not until fairly recently, would be an assignment of copyright to the publisher. So at that point, as a general proposition of law, you can only get so many rights. You can only get the rights that the person holds. So in other words, if when we talk a little bit about things to think about, I might say, well, you might want to think about creating a licensing agreement or some kind of structural way to think about who and to what extent we handle deposits for the institutional repository. And if the person has no rights to give you, that you get no rights. And that may become an institutional question with respect to risk or liability or how we're going to frame that. So one possibility is an assignment of copyright. So the individual that owns it assigns it. This happens fairly typically with publication agreements. One of the great surprises to many folks is they don't seem to ultimately own the kinds of things that they thought that they created, and that's really a function of assignment under copyright law. The other possibility is that you can license to various entities parts or all of those rights. You can break up, you can unbundle the notion of reproduction, distribution, performance, display, and preparing derivative works in ways that are not only creative but complex, equally complex. And those licenses come in two varieties. One is an exclusive license. So once you license exclusively to someone, then for all practical purposes, it's very similar to transferring copyright. That exclusivity prevents anyone else from using those in ways that are inconsistent with the license that grants them all of the rights. And the other possibilities that you find to be much more typical and more the norm in many kinds of settings, including institutional repositories and Creative Commons and some of those other kinds of public license initiatives, are called non-exclusive licenses. And you can give non-exclusive licenses to multiple people and multiple entities, and those can sometimes frame the right. So as we move forward, I'm going to talk about the context of non-exclusivity as a general purpose, because it fulfills, I think, an important legal function, but it also gives some surety to the person maintaining the ownership of their copyright, which, particularly with respect to faculty members and others, that's becoming increasingly important to them. And if it's not, it should be, because that allows them to manage their copyright through time in ways that are not only helpful, but I think help them understand their rights under intellectual property or copyright law in that context. So things you ought to know, and without knowing across the number of folks that are signed up today what your various exposure has been so far to copyright, I'm going to probably be redundant and probably already have been, but I am concerned about those agreements or those licenses or those papers that you're asked to sign and or look at. And I think things that you ought to know, either as folks who may be depositing materials in an institutional repository, or folks who may be on the other end of trying to frame the conversation about how do we want to make use of these materials, not only in the best interest of our faculty, but the best interest of our institutions and various libraries, is this language of I hereby do something. And as a general proposition, if you're reading agreements, that's something that is going to be a trigger for you to pop up a red flag or to become more alert, or something like the hair on the back of your neck standing up, whatever. And some of the magic language might be, I hereby transfer. Well, if it says that I transfer, then usually it means that you've assigned the copyright. And lawyers by nature are trained to be purposefully over abundant in their use of similar verbs. So, occasionally you'll see something like I hereby transfer, assign, grant, give, because there may be cases out there that say something like, well, we like the word assign, but we didn't like grant. So there's lots of historical reasons. But you need to look for that. If you're structuring an agreement, this is the kind of structure you're going to start thinking about. You're going to start thinking about how to require that individual to give you some set of rights to make these things available via your institutional repository. And we also could talk about digital rights management, which I may get into, or at least maybe not strictly digital rights management, but access kinds of questions, and with respect to defining those rights. You want to look for that kind of language. And the other kind of language that I think is fairly typical, at least from a lawyer's perspective, is that the individual has to make some kinds of representation and warranties. And one of the strategies that I may come back to is that legal phrases can be a bit overwhelming at times, and I'm certainly not trying to overwhelm you, because I think that you're all bright, intelligent, competent people and can understand this as well as I do by far. And in that sense, there are some magic terms of art, at least the law thinks of this magic terms of art, and that represent warrant means that I'm really, not only am I promising this is true, but I'm also standing behind that promise. And you'll occasionally get that. You certainly get that in publication agreements, and you'll see that sometimes structured and even licensing kind of construct, because we want to know that it's that person's work. And we want to be able to safely assume that that person has the rights to put that in the institutional repository. We may want them to represent, so that's that work is original. And I have to be careful about originality in that construct. It's not the copyright originality, it's that that person's created, or they've brought all the authors together as joint owners. That's another possibility. Multiple authors could own it. And we also want to know with some degree of certainty, or at least we want them to try to establish with some degree of certainty, that if it includes third-party works, then those works themselves were either under a framework of permission or under the fair use doctrine, or some way sufficiently clear in order for them to include that in their publication. And as we move forward, depending on your institution and general counsel and risk adverseness and lots of other legal kinds of questions, we may want to know whether any statements there are defamatory to that extent. Are they false statements of facts that are going to harm someone's reputation? You know, I'm not overly concerned about that, but you see that as one of the questions that crops up across various kinds of licensing in legal conversations. And the third thing that tends to be fairly common, which is good or bad, often depending on which side of the agreement that you're on, because as you all know, as a general principle, the folks that give you the agreement tend to create an agreement that favors their interest. And if you get the agreement, you may very well have to mark that up. You know, that's my classic publication agreement conversation or contract question. And this language, I hereby indemnify, and fundamentally what that means, and you see this in publication agreements and you see it in lots of other contracts, maybe not so much in institutional repositories. We're saying something like, to the extent that I'm making this representation of warranties, and it turns out at some future date that those representation of warranties were inaccurate, the individual that signed the agreement is going to indemnify or pick up the cost for any litigation related to that. And that's a fundamental burden in some sense of the person signing the contract. And it's not atypical, but it's worth looking out for. And most of my conversation and most of my focus in talking about copyright is to push back to you all and educate you all on the things you need to think about, because you all are generally closer to the factual questions. You understand your local cultures and you understand your local political situations, and you can drive it in that way. And I like to think I provide the tools to make that happen. So things you ought to know, some subset of those are these three things. So things you ought to think about. And I puzzled over this. I spent some fair amount of time struggling with how to consolidate this conversation into an hour framework and what sorts of things that you need to think about across the possibilities of what an institutional repository could mean. So as I said earlier, one view of an institutional repository is we're interested in scholarly works. Other views of institutional repositories are we're taking records from the institution, they become archives, they became preservation entities, and they became all those things. So as a general proposition, you need the framework of the rights that would adequately protect your interest, if I can say that in a not too crass way. What kind of rights can the person making the deposit give to you in the context of depositing it in that institutional repository? And I suspect already there should be some red flags, or at least questions about costs and administration and transactions and all those kinds of things at this point. If I need to individually deal with individual deposits in some framework, then I've really escalated the administrative transactional costs for making sure each one of those are possible. And as a general proposition, the gamut could be I could require them to assign copyright, and I'm not aware of anyone doing that except for publishers, or I could ask them to do a non-exclusive license, them being the person making the deposit. And in that non-exclusive license, I might want to say certain kinds of things about what their commitments are, and those commitments may roughly parallel the slide that had information about it. You know, as a general proposition, I'm not familiar with anyone that requires indemnification of the institution in that sense, but I also might want some affirmative statements that those persons actually own those rights, and if they have third-party rights, or if they have third-party inclusions, what those rights actually might be. And to what extent that I need to certify that to make folks comfortable across the board is going to be yet another question. And then the other question that I think I would at least think about addressing is, as you migrate formats forward, you want to make sure that at least the folks depositing is understand that you have the ability, and in fact you need the ability to do that just because of the nature of technology, and in some way try to frame it in a way that requires you to allow that to happen. So the person making the deposit would allow you to move forward and make migrations. You know, for those of you that have looked at agreements or contracts related to similar activities, even if they're software contracts that we all click I agree and sometimes don't read, if you look at it in that context, mostly it's that notion of all technologies now known and later developed. You know, I've found that strikes folks kind of peculiar unless they've gone through this, you know, law training, and I think of myself as a recovering lawyer. The idea that it's now known or later developed is interesting to them, but it's intended to address this question. You know, we can't foresee what's going to happen and to what extent that we need to make changes or migrate based on technology. And as technology and as digital technologies become ubiquitous, in some sense that's become even more complex. Early conversations were with respect to the VHS, because there were reams of motion pictures out there that they now needed to put in a different format, and no one had contemplated that in the 30s, 40s, and 50s. And how could we address that? How could we address that question? And another question is, what kind of stuff is in the IR, or what do you want to put in the IR? That's sort of my fourth question. What do you want to happen? If it's beyond those kinds of things where you have individuals owning them like a scholarly article, then you may want to shift into the, if they start to look like what I would call special collections or things like that, there may be requirements to really start looking at the deposit agreements that you have within your institution that frame the kinds of rights with respect to what those are. Those are more, at least in some venues, more digital library concerns, but as some digital libraries somewhat conflate with the notion of institutional repositories, I think you need to be savvy to that question. And as a general proposition, I can and have been saying for years that that copyright law is essentially technologically neutral with respect to some facets, but then we have various elements of the law that treat video, audio, sound recordings, and some of the more modern media materials differently. So if I look at a general proposition as the law being technologically neutral, I think it is, and then I have to then concede that there are specific kinds of works that you might include that might have different kinds of possibilities. So if the institutional repository is going to be video, audio, sound recordings, or some combination of those, you can imagine a thesis in some of the more creative areas that would have all aspects of those, and to what extent that you put those in a repository, and to what extent that the individual that created that could have, would have, should have looked at the copyright issues, and to what extent they address those, and how did they do that? Because as we move forward and even backwards, we find increasing numbers of copyrighted works that are orphans, and we don't always know who actually owns those. So even if we want to create a construct of permission, we don't always know who to ask for that permission. So stuff, or how or what the stuff is going to be in the institutional repository, is sometimes going to frame the conversation. And then going back a little bit to my earlier touching on this point, does the depositor actually have those rights that you're interested in inquiring? And more fundamentally, how do you know that? It's been fairly typical across the academic world and libraries and such, and other parts of the commercial world and elsewhere, to have forms. You know, forms are good. Forms are good things. And often those forms are a way to shift responsibility, either internally or amongst individuals. And so we have a form that says, yeah, I attest to the fact that this is in fact a true statement, and I do in fact have these rights. Well, how do we know that? We have a signature on that, but we don't always know that. So there's always some element of risk. And in that element of risk, we have to sort of take an individual and institutional view of what kind of risk can we accommodate, and to what extent are we comfortable with those risks. And then another question is, because I've been getting this a lot, is how can we acquire those rights? And Back to the Future means, you know, we need to proactively look forward about how we're going to frame conversation. So one of the conversations that's ongoing in the community with respect to traditional works of scholarship, if I can revert to that framework, or publications, is, can we create institutional frameworks as a policy question to retain certain kinds of rights to include them in institutional repository. There's been much conversation about Harvard and lots of other institutions and with respect to whether they're mandates or they have to opt out and those kinds of things. But it's really that question, can there be a policy framework for understanding that proactively moving forward? Well, if you've addressed it proactively moving forward, that may lessen some of the other issues related to individual treatment of individual works, or trying to create some kinds of license that folks have to agree to before they make the deposit. And then the other question that I get more and more is the inclusion of looking backwards and trying to retroactively find folks who have done various sorts of things at our institution to put them in an institutional repository. And those might be electronic thesis, dissertation kinds of questions. Can we look backwards and say that we can clear those rights, and to what extent can we locate them, and to what extent do we need to locate them? Well, I can pretty much assure you that many of those things are protected by copyright, and certainly as of 1978, it's automatic protection if this original work is fixed. So we need to understand how that happens, and what is that license going to look like when we try to structure in a way to look forward and backwards. Well, they may or may not be the same license, but you tend to find that administrative costs are less if you have one license that you don't change over time or don't individually tailor to individual users. So there's that question of how can we acquire those? And then here again, is the question that I get quite often in my talks about conversations about copyright. Sometimes I talk about scholarly communication, sometimes I talk about copyright uses, sometimes I talk about copyright in software, or Web 2.0, or ownership, and across the board there's a commonality that you all may or may not share, but it's some version of this question: what are the odds I'm going to get caught? And I always struggle with that question, because as a lawyer, I'm pretty much obliged to abide by the law. So I usually have to think of some meaningful ways to make these things work in a lawful way. But they're really asking about risk, I think. So a few years ago, I looked up on the federal judiciary the statistics for number of lawsuits filed in the United States in any given year involving copyright, and came up with a figure of something like an average of 3,000 that jumped up for about the last 3 years, because the Recording Industry Association of America was very litigious with respect to students who had broadband connections, and put that somewhere like 4,400 lawsuits related to copyright last year. And some people in the room are definitely afraid by that prospect, and some people in the room are just happy, or couldn't be happier about that. And to me it has no significance, because I look at copyright litigation as being a life-changing event, just like winning the lottery. So if I win the lottery, I'm really happy, and if I get sued by copyright, I'm really sad. And in that context, it boils down to, are you concerned about liability? So in the liability question is often, who pushed the button? So we need somebody that directly infringed it. So some people ask me about, well, am I going to be accountable if I'm the person that's creating the institutional repository and actually vetting these things and bring them into the institutional repository, or have some administrative liability? And the odds are probably if you're involved in pushing the button. And then I'm also going to have the conversation about, well, in addition to that, your institution is also going to be most likely responsible, because as a general framework under the law, institutions are responsible for their activities, employees, not only in the copyright realm, but it's called vicarious liability, but it's really in the realm of how we address the responsibility across the work world or the institutional world. And then the question of, if you have a general counsel, to what extent or how do they view risk for the university? Because there's some element of risk associated with all law. And one of the things, when I used to work in radio, so I told the host that when I worked in radio, one of the reasons I stopped radio was because I really didn't want to sit in a room and just talk to myself. Well, I found myself, kind of doing this today. And in that construct, there's risk associated with it. So when I ultimately ended up in law school and started learning about tort law, where you can be responsible for the awful things that happen when you're driving an automobile, I decided to stop driving an automobile. And then at that point I said, well, that doesn't work, because I need to drive an automobile. So we have to take on some amount of risk. And so I don't have a lot of yes or no answers with respect to many legal issues. And sometimes that's going to be driven by, what's the view of your institution with respect to how we create this institutional repository? How detailed, how much vetting do we need to do for the information with respect to what's going to be deposited in it? Well, you have to do an adequate amount of vetting to lessen your risk, and ultimately you want to lessen your risk how much. And that's often going to be a determination, at least in a conversation with general counsel across the board. Another question, going back to that forms thing, is that one of the questions that I get a lot is if, and I'll pick on the library because I'm an endowed chair in university libraries at U of L, so I'll say in the library setting, I'll get a question, well, if we have them sign a form that says they're going to be responsible, and it's the faculty member submitting something to the repository, and they sign the form saying that they have all the clearance and all this kinds of things, are we going to be off the hook? And I immediately have to really ask, who are we? Because in that construct, the library may be off the hook as a political question, but maybe not. And the larger we of the institution may very well be on the hook no matter whether the form was signed or not. So in that conversation, I keep rolling back to the idea of who is responsible and how we do that. So in a lot of situations, I'm really concerned about, what is the licensing arrangement? I want to know who's the owner. I want to know who's the owner. I want to know what rights they have in it. I want to have a conversation about them, or at least I want to create some kinds of structural ways, some administrative ways to deal with that question of transitioning that deposit, that thing, whatever that thing is, into the institutional repository in a way that's consistent with our institutional perspectives on risk and the view of the value of the institutional repository in the larger conversation about scholarly communication. And as you all know, that's a very difficult conversation. And layered on top of that question is, how do we address the copyright? So if the couple walk-away things, and I'm very near, so, I don't think I've had any questions yet to the best of my knowledge, but if you want to send questions, that's fine, because I'm very near the conversation, at least from my standpoint, to try to fit in our target window. But I guess the walk-away things might be those basic questions at the beginning, which I think are really very basic, but I think important because I certainly can, I can say for myself that sometimes I jump ahead and just sort of forget the basics. So, is the work protected by copyright at all? Well, I've come to the conclusion, because it's an original work of authorship fixed requirement in the United States, that the odds are that the work's protected by copyright. And then the second question of who owns that copyright. Well, that opens up a Pandora's box of possibilities for some kinds of works, particularly those that might either be direct deposit items from a special collections or some other kind of framework, or that might be included as parts of scholarly research. And I need to know something about ownership. So I talked a little bit about the creator of the work or the work made for hire. I spent a lot of time talking about intellectual property policies, and that's something that your institution may very well have. I think most institutions do, and most institutions I've generally encounter leave ownership for traditional works of scholarship with faculty members, but that may or may not include other kinds of statuses at that university. And then the question of the third-party works, how are those included, and to what extent we can structure an arrangement where we're comfortable with the person making the deposit confirming that they have somehow some rights to do that. To what extent that we might be on notice that there could be potential infringements, always a question. And then how do we want to make use of the deposited work? And one of the foundational questions is we want to make it publicly available to everyone. Well, that's certainly a worthy goal, but that raises that sense of risk aversion in lots of sectors. And then we move down the scale. Well, do we want to limit certain kinds of materials only to the university setting, which happens with some institutional repositories? Do we want to take some kinds of materials that sometimes happens with dissertations or those kinds of things? We may want to in fact have some embargo period in that context. So if we're looking at that question of and this has become more prevalent even in the NIH construct of the NIH funding requires the faculty member to negotiate at least sufficient clauses to deposit a final peer-reviewed copy of that article in PubMed Central. Well, that requires some negotiation, and it also requires some understanding of what to negotiate, which many of your institutions are already working on. But it also requires some degree of embargo possibility, and many publishers have taken on that task to make the embargo a fairly long period of time. Yeah, so let me see, statistics, and I also have a question, so that's kind of my spiel right now, and I'm looking at a question. How many involved, okay, on the statistics for copyright suits, how many involved academic institutions and how many were successful against academic institutions? And as a general proposition, probably the most common one, or at least the most well-known one right now involves Georgia State University, and it's really related to the electronic uses of materials, but that hasn't gone to court now. If you look backwards into how many involve academic institutions that have actually gone to trial and litigated, made some kind of determination, they're very small. Most of the questions that I've bumped into in case law related really are differences of opinion about who owns either copyrighted works or patentable works. But I also know that as a general proposition, there is a growing interest in the electronic use of resources, and I think the Georgia State University litigation is probably one manifestation of that use. So whether they will grow or not is an open question, but I also know that from my standpoint, I have to really just frame the question of making legal possibilities to do this to lessen risk for not only the individual but in an institutional construct. Another question, how aggressive should libraries be in determining copyright or obtaining permission to include an article in the IR? Some places are rather lax about it, whereas others are very strict. And, you know, that's a good question because I've been trying to cover the gamut of possibilities. And as a general proposition, you know, that's not a good question to ask a lawyer, I guess, in some sense, because if I put on my lawyerly hat, I say, well, you know, we should be really comfortable with it as an institutional question, and the problem with that answer is I don't know what your institutional question is. I do think that one of the ongoing conversations that many of you all are doing is really about talking to faculty about how to best manage their copyright and their publications. So if we're looking at that framework as part of the conversation, I think that moving forward we're going to be increasingly in a position where faculty are managing them in ways that would be helpful to the institutional repository. The third-party works are a lot more of a question in many different ways. If we look at that question as to with respect to aggressiveness, I'm not convinced that every use in the United States requires permission, because I think there's a good and robust fair use doctrine out there. And I think that can apply to some aspects of that. But there again, we need to know something about the 4 factors of fair use. You know, what's our purpose, what's the amount, the nature of the original work, and the effect on the market. Well, some of these things are probably going to have a fairly negligible effect on the market in some sense, and some of them are going to have a great effect on the market. And our ultimate goal really is to make some sort of reasonable good faith estimate of what that might entail and to what extent that we can lessen our possibilities. Okay, and I'm scrolling down the list, probably not seamlessly by any stretch of the imagination. If a master's thesis from 1972, before the change in the law, contained third party under fair use, would that fair use determination be different if that same document was later digitized and added to an institutional repository? Cool. Okay. The fair use doctrine is in section 107 of copyright law, and it has certain kinds of requirements, including the 4-factor test that I talked about: purpose, nature, amount, and effect. And presumably, if I'm reading the question correctly, which is always a suspect, if I make a fair use determination in 1972, and I've decided that as fair use existed in 1972, that this was in fact fair use. Does that change as I'm moving forward into the digital realm? Well, in some sense it doesn't change at all simply because it's digital, because that goes back to my presumably technology neutral aspects of copyright. I think if anywhere they fit within the domain of fair use, you know, we might find some issues with the DMCA of 1998, but as a general proposition, I think they fit within that context. So, but the other thing about fair use is, in some sense, and the Supreme Court has very carefully said, and as you all know, the Supreme Court is sort of the Trump court in the United States, have very carefully said that fair use is an ad hoc analysis at this particular point when I want to use it. So is it possible that it could have been fair use in 1972 and not fair use now? I think it's possible, but I think that it's probably unlikely that that's going to change. And there's always danger and specificity with that kind of answer. But as a general proposition, it's possible that as things grow increasingly older, they have less of a stake in the marketplace, and therefore your market effect could have even lessened in that context. So in sort of a roundabout way, I think that it's possible that you probably have a better chance of making fair use now than you might have at that particular time. Okay. Assuming that we obtain permission from the publisher and our author to post an article on our IR, is it okay to obtain articles from licensed electronic databases? Wow. That is a very complicated question. As a general proposition, that it's probably going to be predicated on the idea of what that, and I'm sort of looking at, I'm trying to reread the question and be somewhat articulate, which is always a danger. If we obtain permission from the publisher or the author to post an article on RR, is it okay to obtain articles from the licensed electronic database? And, you know, that really is going to come back to what that database license says and what the extent of that permission. You know, the one thing about permission is that, and the one thing about licensing is that it can very much define with great specificity the use of a particular item. So in that sense, I would want to know an awful lot more facts about what those say. So if I were asking permission from the publisher, so in other words, I've gone to the publisher and said, this is what I want to do with it, then I would also make clear in that conversation that I want to take this from the database. In the absence of that framework, then I might be a little bit more concerned about that. If the permission comes from the author, then I want to know that the author has the rights to allow the deposit of that. And that typically would, at least in a theoretical model and mostly in a practical model, require that they had managed their copyright in a way that would allow them to do that. And as a general proposition, I think that that issue is going to be looked at in some competitive sense by the publishers. So I'm not certain, I guess, is the best way to summarize it in a very long way. Do you know of academic institutions who assert ownership over undergraduate or graduate thesis projects or dissertations? As a general proposition, and I haven't done specific research across the board, but my general sense is that most institutions don't assert ownership in student works unless there's some kind of other relationship going on. So one common relationship might be that student also works for the institution. Well, that may not apply to any of the works that were in the question except for projects, and I don't know what that project would be, but the institution might have actually hired that student, so they'd be an employment role in the institutional policy construct. But in their student hat, and they're not hired to do something, and they're not working in a scientific lab, as a general proposition, I don't think that most institutions assert ownership of them, and I also don't think that, you know, it's clearly not a work for hire, so I think as a general proposition that universities don't have any ownership in any of those kinds of materials, absent a couple kinds of things. And I haven't seen that generally in institutional policies. And I think, as near as I can tell, that I don't have any more questions unless I get something in the chat box. So if I have no other questions, and I don't see any pop up. I feel like an auctioneer at this point. If there's like no questions popping up soon, then I'm going to say I appreciate you all coming.